Hello and thank you. Haven't been to London for a while, and I really appreciate you inviting me and waking up at 5:30 for the train. I'm on sabbatical too, so that was extremely painful. Anyways, the reason I am happy to be here, because I don't accept every invitation to make speeches about Bedford, because I'm a little saturated with the case, is because I like London. And when I characterize my case, when people ask me, how did this case get created, I always say it was created out of the ashes of other constitutional challenges I brought. And guess what? These challenges, these other ones, the early ones, were all brought in London. Now it's kind of weird. I don't think London's known as kind of the hot seat for radical change. And somehow I ended up in London doing most of my constitutional litigation at the beginning. Which leads me to a simple lesson that I'm going to try to give you in the 40 minutes I get to speak, which is you want to change the world, pick your timing and your strategy very carefully, not just the argument. There's a time and a place for arguments to be made, and Bedford was a resounding success because it was brought at the right time. What I'd like to do is talk to you about things you don't know. I'm not going to tell you about the judgment. Read it. It's long. But I'm actually really proud to say it's the first time I've actually been involved in litigation where I read the judgments and I understand what they're writing. They're clear. We may not agree on every point, but it's really clear what happened in the case. So I don't want to talk about that. I want to talk about the evolution and history of the Bedford case and what brought it to success in 2007 or 6 when I started it. So let me first give you the short history of sex law, okay? I can do this really quickly because just seeing where we stand will explain the paradox that gave rise to this case. It's really simple. Okay, first of all, historically, people usually think past eras were more hung up about sexuality because we had the 60s sexual revolution and all this stuff. It's not true, actually. Very bawdy societies early on, there were really not a lot of laws directed against sex work. There was laws directed against things that were associated with sex work. So with common law, you had the prohibition on bawdy houses, and you had the living on the avails offense, because it was all about disorderly conduct and vagrancy. They wanted people to have a point in their life where they were working, and they didn't want congregation of undesirables in one location. No, you'll never read in Blackstone or Hale or anything, sex is bad and women shouldn't sell sex. You don't get that. You get that today. You don't get that back then. So it was all about really control of the streets and nuisance. That's all it was. Street prostitution was never addressed other than by this grab bag called vagrancy, where vagrancy was a status-based offense, which basically said if you were out at night in London or, Toronto, and you couldn't account for yourself, you were a vagrant, and they'd take you to workhouses in England. So it was just a way of controlling the streets. They weren't really concerned about the actual sexuality of it all. Now, in 1972, the problem starts, because we realized we can't have vagrancy law anymore. You can't, in a modern civilized era, have laws that say it is wrong to be unemployed, because that's what vagrancy was. They needed to move in the modern era to conduct-based criminality, not status-based. You follow me? So that was the birth in 72 of our soliciting law. Okay, so that fills the story. We had common law offenses of bawdy house, living on the avails, that then found our way into statute, and in 72 we had soliciting. Now here's what people don't really know. In the 1980s, a false crisis was constructed about the sex trade that resulted in us having to do more law reform. It was a false crisis because it was a result of two things that were a mistake. One, did anyone criminal law study a case called Hutt, 1978? Hutt's an interesting short case where the Supreme Court of Canada says to be guilty of soliciting, Crown has to prove pressing and persistent conduct. I don't know why they decided that. It's interesting because as a result of that case after 1978, they couldn't enforce the law on the streets. Because any sex worker would know, all they had to do is say, you looking for a date? No? Have a good evening. As opposed to, come on, come on, come on. That's how you stayed within the law. So at the same time, they couldn't enforce the law on the streets. A very horrible murder happened in Toronto called the Emmanuel Jock murder. He was a shoeshine boy who found his way into a massage parlor, and he was killed in the massage parlor by these psychopaths. As a result, every municipal jurisdiction decided to clean up the indoor establishments that were thriving in the 70s. And when you clean up the indoor establishments, you put more people on the street. So as a result of Hutt, and the law enforcement patterns, I can tell you from personal experience, in the early 80s when I started as a lawyer, you couldn't walk down Jarvis Street around Dundas without being confronted by a horde of sex workers. You gotta remember, this is the 80s. Everybody had the big hair, okay? The flock of seagull shit, okay? So, I mean, these people stood out at the street corner. The municipalities were freaking out. Toronto, Calgary, Vancouver, we had to do stuff. They brought injunctions in BC. Calgary created bylaws against prostitution. All of it failed. So they lobbied the feds really hard and said, our cities are being destroyed by sex workers, do something. So, in 1985, John Crosby, who was the Minister of Justice, passed the communication law. And he was extremely clear about the government's objective, which became really important in the case. The only thing they were trying to do in 1985 by passing communication was say, get off the streets, which is the exact words Justice Dixon uses in 1990 in the prostitution reference. Well, there's the problem. You can't have a get off the street objective coexist with a body house law. If you say get off the street, you have to have somewhere to go. And so the two laws couldn't coexist. There was a contradiction waiting to happen. So, in 1990, within 5 years of the law being passed, constitutional challenges were brought and made its way up to the Supreme Court as a reference. Huge mistake, people. I was excited too as a young lawyer. Oh, use the charter, change the world. It was a mistake. 5 years into a law, you don't know what its impact is, so you have no empirical data. The charter wasn't ready. Go read the 1990 prostitution reference. Look at the arguments. They're embarrassing, even though the decision takes 100 pages to dispose of them. Vagueness. I've tracked all the vagueness challenges. There's been 47 vagueness challenges in Canada. It's the most frequent charter claim. It's only succeeded once. Everything is comprehensible to a judge. Economic liberty. You know that's not a good argument. There is no property rights in the charter. There's no economic liberty in the charter. So they fell back on what seemed like an obvious argument, free speech, communication, free speech. It's not about free speech. It mischaracterizes the nature of the problem. So it was very clear that charter enthusiasm gave way to a very ill-founded challenge. And so that's why I start off by saying the lesson I want to teach you today is you've got to be patient and strategic if you want to use law to change political structures. It's kind of pedestrian advice. I know it's not that interesting. But it was a hard lesson for me because I'm a very impatient person. I want everything yesterday, right? So I'm really thankful the 1990 prostitution reference came because I was just about ready to do one myself. And it would have been ill-fated also, academic the way the 1990 case was. I decided as a young academic that my way of giving back to the world, or kicking the world, I don't know which of the two it is, would be to challenge all the consensual crimes in the criminal code. Every crime where the two parties to the transaction want it to happen, whether it's pornography, drug-taking behavior, prostitution. I was going to do prostitution as the first challenge. Because I was not thinking strategically that, oh, it's a new law, it's hot, it's a hot topic. I was thwarted from doing it, so that forced me to do obscenity as my first challenge. And I did it here. And just to show you, got to pick your forum. Because here I was representing a guy named Emery, who's kind of an infamous guy in London. He was a bookseller, Mark Emery, the Prince of Pot, now extradited to the States. He started in London as a bookseller. There was a really kind of misogynistic, horrible rap tape by Two Live Crew called As Nasty as They Want to Be. And the London police said, we will not tolerate the sale of this tape in our fair jurisdiction. And of course, if you know anything about Mark Emery, the next day he was selling them and advertising and selling them. So he brought this challenge based on vagueness, the bad argument, trying to come up with some new Section 7 doctrines that we could develop. But it just was silly. I showed up in court, they gave me a supernumerary judge. That means a retired judge, which means someone who doesn't have anything better to do with their day, so they want to still sit. It means they're old. He didn't want vulgarity used in court. You couldn't play the tape. I don't want to hear the tape. I said, you have to hear the tape. I've got an artistic merit argument about the music. No, and had the Crown read out the lyrics with using like little beeping noises every time, you know, which is every word's a beep. I had evidence from Project P, which is the OPP division that deals with pornography, where the cops, I can't believe this, came to London and they were going to testify they don't know what obscenity is. I'm making a vagueness challenge. The best evidence in the world. The judge wouldn't allow it in. We don't need evidence on a charter claim, which is 100% wrong. 1990, the charter wasn't ready for that challenge. It hadn't developed yet. Plus, it was the wrong forum. I was arguing about the integrity of a rap tape and whether it was misogynistic, and there wasn't a black person in the courthouse or a woman in our courtroom. Like, it's just a bunch of men arguing over it. It didn't make a lot of sense. So that went nowhere. Then I decided, more close to my heart, to go after the pot laws and do it again in London. I didn't learn my lesson yet. I'm going to do it in London. Because you had a store owner on Richmond, had a place called the Organic Traveller. I can't remember now. I think that's what it was, a hemp store. And so he calls me, he says, I want to get busted so I can challenge the law. What should I do? I said, sell pot from your store. So it's easy enough. So, get this. So he decides not to sell pot, which is a good move. He's selling clones so people can grow pot, which is a lot better. And his first sale's to an undercover cop. Like, so how convenient is that when you want to get into court? So in any event, I was developing an argument called the harm principle as a principle of fundamental justice, meaning that there is a threshold of harm that must be met before government can criminalize conduct. I wanted to do it with the prostitution. This was the argument I was developing for the prostitution claim, that there isn't some great harm to the proper functioning of society. But I actually thought it'd be better to do it, I'm starting to think strategically, with pot. Because there's actual empirical evidence about medical harm. Most of the evidence about the harms of the sex trade is kind of that loosey-goosey social science stuff. So I thought if I go with real hardcore science, 3 weeks in London, 17 experts, that's the way you do a constitutional challenge. Leave no stone unturned. I had a great judge, supernumerary again. They tried to do the same thing with me, but this time the guy was open-minded. Wouldn't go with us. But actually dramatic impact, because the headline in the Globe in August 1997 when he released his judgment was, marijuana is relatively harmless. We lost the principle of fundamental justice challenge, but that's what's fueled the whole last 10 years of debate about legalization, was that headline. But here's the thing. It goes up to the Supreme Court of Canada on the harm principle. I can't believe the Supreme Court of Canada decided there's no such thing as a harm principle. That government of Canada can make decisions on criminality based on paternalism, they said, and based on protecting core values. I'd like to know what those core values are, if they're the same as mine, okay? So, I was really, really sad. I worked hard on the pot thing. It had a very personal aspect too, okay? I don't need to be designated a criminal for choices I make that don't hurt anybody, okay? So it was very personal to me. I didn't get to argue the case because of illness in the family, so I don't know what happened in Ottawa. But when I finally read it, I was almost crying, because I can't believe 10 years of work for the Supreme Court of Canada to distort the record, which they did, and come up with a decision which I didn't think was good for the development of public policy. But then the eureka moment happened. And this is what's fun about law. Judges close doors, and they usually leave a little bit open for you, okay? Because they're too afraid of having a decision that forecloses the future development, okay? You gotta look for the door opening. So when they rejected the harm principle, they then said, but there's another principle of fundamental justice. We never argued this, by the way. They created this crap, saying, there's a principle known as gross disproportionality, that if you can prove the legal regime causes greater harm that outweighs the importance of the objective, that's a fundamental justice flaw. And I go, oh my God. I stopped crying about the marijuana. You know, I can't believe what they just did. They gave me the sex trade challenge on a silver platter. Because while I was maintaining a watching brief from 1990 on the sex trade, things started to happen in the 90s that were very disturbing, but I didn't know what to do with it. 1995 it starts. Jurastat, StatsCan reports, their first report ever on street prostitution. They report that in a 4-year period, 63 street prostitutes have been killed, 60 of them women. That's big numbers, okay? And by 2000, Jurastat, StatsCan, is now having a category in their statistical analysis called dangerous professions. Occupation at risk, that's what it's called, occupation at risk. Let's see what is in the category. Sex work, taxi drivers, police. Of those three, who do you think suffering the greatest mortality rates? Not even close. As much as when a cop gets killed, you hear about it for months, you got to look at the numbers. It's not an occupation at risk compared to the sex workers. And then in 2002, in the beginning of the year, the most horrifying thing happened to consolidate the claim, which is digging up the bodies on the pig farm. Suddenly, I realized what gross disproportionality would be about. The court created a doctrine that perfectly suited the problem that had emerged since 1985 communication law. And I just want to be clear about something. This case is not about Picton, about some psychopathic serial killer in Vancouver who killed a minimum of 26 street workers. If you think it's about Picton, you're wrong. Picton is the tip of the iceberg. The history of serial killing has been the history of preying on sex workers. It starts with Jack the Ripper in the modern era. At the time that Picton was picked up, they also caught Gary Ridgway in Seattle across the border. He's the Green River Killer, the most prolific serial killer in the United States with documented 48 killings, all street sex workers. Let me read you something. He obviously pled guilty and living out his life in jail. Here's what he said about why he did it. I picked prostitutes as my victims because I hate most prostitutes and I didn't want to pay them for sex. That's not the important part. That's the misogynistic part. I also picked prostitutes as victims because they were easy to pick up without being noticed. Oh. Got to read about how we enforce the law and push people into darker areas of cities. They're not going to be noticed. I knew they would not be reported missing right away and might never be reported missing, which is very true. I picked prostitutes because I thought I could kill as many of them as I wanted without getting caught. Okay, he's reflecting on the stigma about sex workers and how no one cares. But he's also reflecting on the fact that the way the law is constructed, they're prey for easy picking. They're the easiest victim to pick out. If you're a serial killer, a mission-oriented serial killer where you want to rid the street of all the scum, because that's what they usually say. So I don't want you to think this is about Picton. The problem is so much bigger. Okay? Picton's 26 victims. Do you know Project CARE? Between Edmonton and Calgary, they're looking for 80 missing women, and they say from high-risk professions. What is that high-risk profession? It's not your parking lot attendants, okay? They're street workers. Winnipeg, they're looking for about 75 missing women. So the problem is deeply prevalent, and when I dug deeper, when I started reading about Picton and all these thoughts are occurring to me, I discovered the following. The government of Canada has commissioned studies since 1985 looking at the effect of their law. And all the researchers say the same thing. They either predict increased dangerousness or they say it's becoming more dangerous to work on the streets. I then dug deeper, and I didn't know any of this, that the world's changing. That all of Australia has decriminalized, New Zealand's decriminalized, Germany's criminalized, and a lot of other countries are talking about it. So, the question was, how do you fit these new revelations that were emerging in public discourse into a constitutionally recognizable doctrine? That becomes the lawyering task. Clearly, we're going to focus on gross disproportionality because that's the little bone we were thrown. But post-1990, the prostitution reference, we also got Rodriguez coming down, arbitrariness, I used that, and then a case called Haywood in 1993 about overbreadth, overshooting the mark. So this is my lesson to you. The prostitution reference didn't work because the charter wasn't ready. People wanted to be the big shot. I want to be the person who invalidates the law. It's not about you. You need to wait until the tools are there. Otherwise, you got to create the tool. And that's really hard. And my experience in the plot litigation about trying to create a principle of fundamental justice, really difficult. Better to find an existing principle and stretch it and manipulate it to suit your situation. So, I had the law. Now the question became strategic. How much time do I have? I have no clue how long. I just talk, and if you don't stop me, you'll be here like, yeah. No, I can't be finished yet. Okay.
At least 25 minutes.
Oh, good. So now became the issue of how do I prove that the law contributes or causes harm? I think it's pure common sense. This case was built on common sense. Think about it for a minute, okay? I was going to use common sense as factual proof. And by the way, courts have said you can do that. Read R.J.R. MacDonald. You didn't have to prove that advertising encourages people to smoke. Why? LaFerre said, I don't need evidence on that. Why would companies spend billions of dollars advertising if it didn't influence your decision? Common sense is important. So think about it. Communication. You need to be able to talk to screen for safety. Okay? People aren't talking telepathically anymore, okay? You got to be able to communicate. Section 213, 1C prohibits communication. Second, it's clearly safer to work indoors. This was the easiest part of my case. It's a part of my case which, by the way, is supported by a lot of empirical data, but I knew I had 5 judges. I knew 3 of them were sports fanatics. So I just showed up and said, you understand home field advantage. It's the same thing. Everyone's more comfortable in their home turf. You can control your environment. And then it's common sense that you could use some assistance as a bodyguard or security. Less dangerous professions have recourse to bodyguards. Why shouldn't you? Yet living on the avails doesn't allow anyone to take money for services, whether they're security oriented or not. So I want to just go in court and have a one-day hearing and argue what I'm just saying to you. And then I thought, oh my God, what if my common sense is not common? Like, what if the judge doesn't see it? I know the judge I'm going to pick. So I go, okay, I got to put evidence together. 2 cases called Danton and McKay from the early 90s. The Supreme Court of Canada says very clearly, we do not want to decide constitutional cases based on the rhetorical flourishes of counsel, the stuff you like. We want some what are called legislative facts, put some meat on the bone. So that's what I decided to do. Even though common sense dictates that the law increases the risk of harm to people engaged in legal activity, I didn't want to end up being criticized, losing the challenge and saying, well, you did the same thing as the prostitution reference, you gave them no meat. So, the advantage I have professionally is that I have a lot of you people, okay? And you're all really eager, at least in first year. I get you in first and second year. And you want hands-on stuff, you know? There's only so much Hegel you can read, you want something hands-on. So I always do my cases with volunteer students. I had 12 students in the initial run. I used my Innocence Project. We took a break off innocence work, and we managed to interview and provide affidavit evidence from 23 witnesses. Some experiential, people working in the trade, working in sex trade associations, and a lot of Canadian academics. I thought we put together a very coherent presentation of empirical evidence that all speak to the harm issue and the harm reduction possibilities of moving indoors and communicating and hiring security. Little did I know that when I'm trying to satisfy the Supreme Court's request for legislative facts, and I came up with a lot, that the Crown, not knowing what the argument would be, because they've never figured it out, they just, okay, they got 23 witnesses. We're going to get 33 witnesses. It became like a pissing contest, okay? And it was really weird. You had their experiential witnesses talking about the horrors of working in the profession, ours talking about the horrors of the street, but the tranquility or relative tranquility of moving indoors. It became like whose reality is real. They're both real, is what I explained to the court. And currently the law is only looking at the more depraved scenario and not at the more independent, autonomous one. The battle of experts was the weirdest thing I've ever engaged in my life. I'm not a social scientist, I know a little bit, but I realized quickly that you don't have very good science when it comes to the sex trade. It's what you call, in statistical analysis, a hard-to-reach population. It's very hard. If anyone ever says to you, 35% of all sex workers are addicted to crack, just say, how do you know that? How do you know how many sex workers there are that you can make that estimate? It's a fluid population that changes all the time. So it's qualitative analysis that's impressionistic, but is not definitive. So I didn't have good definitive evidence, and the Crown actually hired social science experts to critique my experts. The case got really derailed for a year and a half, all about the right empirical evidence and the social science evidence. Ultimately, I didn't care, I just played along because my position was it's common sense, reflected in every government study, so how dare they show up in court and say I'm wrong when their bosses have said I'm right, plus the international experience. So we had enough empirical data, but to be honest with you, it's 88 volumes that's going in front of the Supreme Court of Canada. And there's a lot of smoke and mirrors in there, and a lot of distracting points. Because we tried to be focused. We were very constrained and focused in our presentation. Every one of our witnesses only spoke to the issue of safety. The Crown's 33 witnesses speak to every issue about the sex trade, and I'll be frank with you, when I got their materials originally and I went and started reading them, I said, I don't think I want to do this case. I was reading really horrible stories. And I was making me feel guilty that I was missing the point, that I was actually going to do something that would make the law or life worse for sex workers. But then I realized I was reading about caged women in Thailand. It's not Thailand. Okay, yes, there's trafficking that occurs in North America. I'm not naive. But I started to realize that all their horror stories actually bore no relationship to what I was trying to do. And you can find horror stories, and you can find stories of triumph and redemption. So I felt pretty good, but we had to deal with the Crown doing this really broad brush approach. They've never had an answer to our claim, so here's their approach. Sex work is inherently degrading. Sex work is inherently violent. So forum doesn't matter. If you're indoors, outdoors, you're in your church, it's all degrading. It's all emotionally scarring. Melissa Farley, one of the worst social scientists in the world, says 92% of all sex workers suffer from PTSD. That was a 10-minute diagnosis, by the way. So, what the Crown tried to do was say, look, Young and his constituency are wrong. This is an important law. It's about protecting the degradation and lack of dignity that comes to women associated with the trade. And Parliament's entitled to enact a broad prohibition saying no one can do this work in these forums because we want to save you. It's like 200 years ago we'd say save your soul. But we can't say that anymore. We want to save people from this life of hell. They did this because all my arguments are based on balancing. All the Section 7 fundamental justice arguments, you balance the violation against the importance of the state objective. So they had to figure out, how do we balance something against harm, Picton. So they thought, okay, it doesn't make sense to say, as Young says, the law is about nuisance. Nuisance can't outweigh mortality and morbidity. So they want to say, no, it's much bigger. It's about equality, very essence of promoting equality for women. Okay, it's not a bad argument. It's the best they could do. But it's a better argument in this room and in Parliament than it was in court. Because that was never the objective of the law. Maybe it should be. I don't design the laws, I just interpret them. If you ever think Parliament ever cared about the moral and physical welfare of sex workers, you're living in a different world than I live in, okay? It had nothing to do with any of that. You can't employ in constitutional law what's called a shifting purpose approach to the legislative objective. It's fixed at what Parliament decided in the 18th and 19th centuries. So that's why this case was a victory, and an easy victory, because the Crown had very little to balance. The increased risks of physical harm is there because the law prevents you from taking rudimentary protective measures. To balance that, the state's saying, we can do that because we have the important objective of preventing street congestion and nuisance. You can't hurt people to improve the movement of pedestrians and cars on a street. That's trivial. Maybe to protect the very integrity of equality and womanhood, yeah, that could balance against the possible risk. But I'm not even sure anything balances against being abducted and being found on a pig farm. That's why I think this is a no-brainer case. And the law does contribute to that. Doesn't cause it, but does contribute it. So I think even if you have a moral aversion to sex work, which is a legitimate political position I don't agree with, but it's a legitimate position, you'd still have to say it'd be perverse to balance the state's interest as outweighing the sex worker's interest in physical security. There's no two ways about it. You can't win this case. The law can be modified to take away my argument, which is just create all sex work to be illegal. The only reason my argument works is because sex work is illegal. And governments do not have the right to discourage legal work by endangering you. It's ethically unsound. I can make this argument in my sleep. I was given 5 days in front of Justice Himmel and 3 in front of the Court of Appeal. But that's all I had to say. You can't use the law to discourage legal activity if the law ends up putting them in a worse physical state. It violates the whole notion of the social contract and the rule of law. Law is supposed to protect us. It's a perverse inversion of the rule of law when the law is contributing to the very insecurity we created law for in the first place. That's why it's a successful case. So that's pretty much what I want to say, but if I have more time, I will talk about the degradation issue. Okay. Okay, so the government's point about degradation. How to say this? Okay. It's clear that our current objective in our sex work regime of laws is not to protect the sex worker. So the Crown's argument doesn't work. That's why they lose. But in Sweden and in Norway, the argument has been successful in convincing governments to create an asymmetrical approach to sex work prohibition where the Johns are criminals and the sex workers are victims that are never charged. So this is based on this notion that sex work is degrading and we've got to knock out the demand side and tell Johns, sorry, you know, it's not something you can do in a civilized society. Here's the problem. I don't know, degrading, not degrading. I have a lot of trouble with that word, by the way. I know lots of stuff that's degrading that has nothing to do with sexuality, and people never use the word. But suddenly you talk about sexuality, we're very confused. And we do fluctuate a lot from periods of condemnation of sex work to periods of tolerance, and don't forget, periods of praise. Just read about Toulouse-Lautrec and all the French Impressionist painters. Those beautiful paintings that you go to galleries for, you probably wouldn't see if they weren't in bawdy houses half the time, because the only satisfaction they were getting in life. Read the history of the Impressionistic painters. The French madames were the patrons of the arts. So we've always fluctuated in our approach. But what's currently happening in the Crown's argument and what will be advanced to the Harper government is a very ideological driven point. It's a political point. To say something's degrading or inherently degrading cannot be an empirical statement. Nothing's inherently anything, I'm sorry. It's like the same thing. Are human beings inherently good or inherently bad? Who cares? I mean, really, it's going to help you to say it's inherently good or bad? It doesn't help understand the human condition. It's a myopic way of looking at the world. First of all, just as a pragmatic point, commercial sex is inherently degrading. Yeah, right. That doesn't make sense to me. Okay? I understand it intellectually, but it doesn't make sense to me because it doesn't reflect the society I live in. And I'm not an apologist for our society. I'm just reflecting, I'm a mirror. But how can you say commercial sex is degrading when, you know, I've done a lot of work in the obscenity field and I've seen the change in community standards. And you can all go home right now and go on Rogers pay-per-view and watch hardcore sex. How is that different than prostitution? How is it different than the woman who's being paid to make the pornographic movie different than what's happening in the sex trade? And it's almost normalized. Just go through your pay-per-view. Look how many porn channels you have, okay? Commercial sex is inherently degrading. So how is it that we have this perverse sort of celebration of celebrities like Charlie Sheen or even Lady Gaga? It's like, lots of people are making money exploiting sexuality every second of the day. So to suddenly say commercial sex trade is inherently degrading, maybe so, but it's sure not the society we live in. And why is you're not making the same complaints about everything else? Probably do more to attack degradation, attacking the way advertisers use women's bodies to sell products than the actual sale of a woman's body. So we live in a highly sexualized society. You may not like it. Sometimes I don't like it in what I've seen the changes, but it's a reality, and you work with reality. Creating legal policies based on an artificial notion of humanity is just doomed to failure. You know, I know the ideological argument because it's the one I have the most trouble with when I do interviews. Because when they can't debate me on the harm issues and the security issues, I get this every time in every goddamn interview. Mr. Young, honestly, how would you feel if your daughter became a prostitute? The other side always says prostitute, we're supposed to say sex worker, you know, it's very ideological. I always said the same thing because I hated the question. I don't like people personalizing issues, especially on television, public forum. I don't have a daughter. That was my answer. I do, I have a son, so it was an honest answer. But the reality is, if I wanted to engage them in the debate and address their personalized question, I'd say, look, I guess my real answer is, if I had a daughter, I'd prefer she doesn't do sex work. But I also prefer she not be a lawyer, or an acrobat, you know, or a skydiver. But I tell you this much, if she makes the autonomous choice to enter the sex trade, I sure as hell don't want the law contributing to an increased risk of her harm. And I think any good parent would say that you're going to overlook your child's ethical choices and worry about their physical safety. So that's how I started dealing with the claims about the degradation. But I got to tell you something, just a personal opinion. Ideology is really anti-intellectual. Okay? You got to have a more ad hoc approach to life, okay? You can't sort of think everything in terms of some Procrustean bed you've been placed in, okay? And this is what I found about ideology in this area. It's so thought-terminating. Because you don't have to think through a problem, you just make the answer consistent with your ideology. And you're unwavering. Every witness I cross-examined for the government, I asked the same set of questions to, but inherently degrading. I said, wait a second, let me conjure this up for you. Tell me what you think. 55-year-old male, widower, wife died, chronically shy. His wife was his first girlfriend. He's not so old as to give up on his sex drive, but really doesn't know how to approach women. Are you telling me that it is morally wrong for him to work out an arrangement with a sex worker in this scenario? And they go, absolutely. And I just look at them, you're really insensitive. You realize that's insensitive. Why should someone be deprived of one of the wonderful parts of human life, sexuality, simply because we don't like the idea of paying for it, knowing that not everybody has recourse to sexual outlets, especially someone who's 55, been married 30 years, chronically shy. I thought it was a great scenario. And they just look at me, no, it's disgusting. It's like, oh. It always bothered me because I'm 55, but my wife's around. So anyways. Okay, so it makes you insensitive, but it also makes you a liar. Okay? Romney and Obama, they're both lying. Come on. They make stuff up to suit their ideology, and then sometimes you get caught on it, sometimes you don't. So, government appeared in court saying indoor sex work is just as dangerous as outdoor. I say, where's your evidence? We don't need evidence. If you say something is inherently violent, what does it matter if it's indoor or outdoor? So that's just an argument. The court needs some legislative facts to make a decision. You're just reflecting on your ideology. But it gets worse. I had 3 witnesses on the Crown side testify that the age of entry to sex work is under 14. I go, oh my God. This is stuff that was bothering me, right? Am I trying to open up a business which is really just for runaways that come from broken homes? It's like, oh no. But then you do your due diligence and you read every goddamn study the experts put into their affidavit, and you got to do this with ideologically driven witnesses. It was unbelievable. First of all, one of the 6 studies relied upon had the average age of 22. It was just wrong. It was just outright wrong. But the way they distort things was, they say the average age is 14, and 4 of the studies did say that. They were all studies done with a population of women who entered the trade before 18. So obviously, do the math. Your numbers will be deflated because you're not getting the people who entered when they're 20, 25, 30. So you just distort things to suit your purposes. And that's kind of the extent of the debate that goes on in political sectors. But I got to tell you, I am proud of our courts. Because I'm usually a critic. I don't say nice things about judges generally. But they didn't fall for it. They didn't fall for the scare tactics about the women in cages. They didn't fall for the ideology, knowing it's not an empirically sound statement, it's just an opinion. And I think they realized that we need a rational approach to the public policy, and the only way you're going to get a rational approach is not from the court designing the new rules, because they can't, but in validating laws to give the incentive to Parliament of Canada, hopefully not Harper, to come back with a set of rules that respect the security interests of women, respect the interests of communities, respect the interests of Johns. I know that's a weird thing to say, but they're part of the equation. There are ways to do it while you still establish safety nets for the people who shouldn't be in the profession and need to exit. That's a non-criminal law issue. Focusing on criminal law has led us to not focus on the need for safety nets, because most street workers, I don't know, most, you can't say that, but a good proportion are survival street workers who do not want to be there and would welcome an opportunity to get some solace and comfort by getting off the street. So anyways, I probably said what I need to say, so thanks.